Thank you very much.
Yes, the
Uh,
stage is yours. Welcome.
so yeah, thank you for this time and yeah, legal talks on M&A and IP. This is the presentation we're going to have. And well, if you're buying vegetable or fruit, you want the one like this apple. It's looks good, smells good, and definitely you don't want an apple that is rotten or moldy. If you're buying smartphone, you want device that is working, not just the shiny case. The same is with business. My name is Stefan Basista, and I have fancy picture as well, but I have 10 plus years of experience in top business consulting, and uh, I'm glad that I can share my experience with this topic with the audience. And first of all, let me thank the team behind this for holding this conference and also for the opportunity to speak here. It's an honor for me. So that's for the introduction, and let's jump into the agenda. Uh, as this topic is about IP, let me start with the first point in our agenda, and I would like to attribute the background picture to the Copilot by Microsoft. Just to make all things as it should be. And now let's move on to the more legal agenda. We will talk about the standard transaction process, how this look like. And also we will talk about due diligence or legal investigation or legal audit, whatever you say. And afterwards, we will close with some common pitfalls on IP in the transactions. So let's start with our first topic, and we will briefly discuss the structure of the transactions. I don't know if you are aware of the transactions as such from the business side, but hopefully this will give you some framework and basic idea what is the legal stuff behind the transactions and what is very important for us lawyers to help you to guide you through the transaction to achieve the desired outcome. So the basic types of transactions are either share deal or asset deal. What is the difference? If you have asset deal, you're buying an asset. So you can imagine having a cake. You're buying just the cherry on the top because you like it, you want it. Yeah, it might be some IP, it might be software, it might be a project, it might be some real estate, some buildings, or any other stuff, but specifically that kind of stuff. There are some important things to think about that as well, because there, in terms of European Union, there are some connections with the employees performing under this or using this kind of asset. But let us focus that you are just cherry picking. You have the asset. On the other hand, if you have share deal, you want to have share in the cake in its entirety. And now you need to think about, am I going to buy the share, buy 100% share, or am I going to have a joint control with someone else? Will I be minority shareholder? Will I exercise the exclusive control? Will I have majority? And these kind of questions needs to be raised in advance, because if these are not addressed at the beginning, they might and most likely will be addressed, but not as questions, but as problems in the future ahead. So it's important to think about the rights and obligations and how to balance them in this kind of cooperation if share deal is in place and you are not the only shareholder. So these were like main types. As regards the forms of the transaction, by far the most popular form is purchase. You can imagine that everyone is purchasing. You can purchase this apple, but most of the transactions are about the purchase and sale. But still, you have other options. Let's name some of them: merger, demerger. This serves mainly, or from my practice, I can say that serves mainly in intragroup reorganizations. So you have various subsidiaries, and you need to organize them in the other way around. So these are frequently used for this kind of stuff. And you have also consortium, which means you want to make a common joint venture, let's say. Yeah, so you want to have business together with someone else, but you don't want to register a special vehicle, legal vehicle for that. So you don't have any special limited liability company in which you would become partners. You can just contractually agree on performing this business together as separate legal entities, and you form a consortium. As regards the transaction process, first of all, one needs to realize that, yeah, I want to sell my business. I want to sell my something. Or the other party needs to realize, yes, I need to buy. I want to buy. Why? Because I need to expand. I want to go to the further jurisdiction. I like this project, and I believe it will be very profitable in the future. So these might be drivers behind the thinking of the parties. So there might be some decisions to sell or to purchase. Then these two parties need to mingle around and chat and see if it's going well, and they can imagine pursuing the transaction. They end up with signing a non-binding term sheet or memorandum of understanding. Afterwards, the legal stuff begins to roll, and the due diligence or the legal audit is being performed. Hopefully, everything is cleared and negotiated, and we will find ourselves signing the SPA, and voila, that's the end of the transaction. Let me say that it's the beginning of the transaction for the purchaser, because many times this is like, oof, we are off. But no, it's just the beginning. That's the other. That would be the other presentation. So let us focus here on this transaction part. In the preparatory state, it means before signing of the SPA, we do some market research. We have these informal negotiations. We focus our negotiations to several parties. Then we decide that, yes, you are the one that we can imagine selling to, and the purchaser might be willing to buy. So we specify some basic terms of the transaction, of the business, and hopefully you manage to write down some notes, and we call it term sheet. For me as a lawyer, I need to say that term sheets are very crucial, because it helps us understand the agreement between the parties and what is the baseline for us to start with when drafting the transaction documentation. Furthermore, you need to realize that especially when the businesses are big enough, there is a state or authority that might have speech as well, and some transactions might be subject to approval of competition authorities such as European Commission or Competition and Markets Authority or Federal Trade Commission in the US. So maybe the clearance of these authorities would be required. And yeah, we are moving on. We are performing due diligence, legal audit, and we are trying to find if the apple is okay or not. But even in this stage, we haven't signed SPA. By the way, SPA in this M&A terminology means share purchase agreement or sale purchase agreement. In principle, it's the agreement based on which the purchaser is buying stuff. But even we haven't signed that agreement yet. Still, if the parties are negotiating in goodwill and one of the parties decides to leave the negotiations without any reasonable explanation, this decision may cause the other party some damage, some costs spent on legal staff, attorneys, advisors, or even internal processes. So this is the damage that was caused, and the leaving party might be liable to compensate this to the second party, even though no agreement have been signed. So it's in Latin culpa in contrahendo, but you don't need to remember that at all. So just to give you some maybe point to think when you are in the middle of the transaction, it's good to like address things, and yeah, you anytime you can agree that okay, it's not working for any of us, and yeah, let's finish it. But it is needed to address this as well. So in order not to be surprised by the second party suing for some damages. Yeah, okay, so the term sheet, which we lawyers love, summarizes the principal things about the transactions that are going to take place. Besides the price, besides the composition of the corporate bodies or something, yeah, it might contain the termination options for the negotiations, so-called break fee or breakup fee. Definitely, you want to establish confidentiality either in the term sheet or let's say a non-disclosure agreement, which can be a separate agreement. And of course, you can have you should have the exclusivity. Okay, we agreed on the principal things. We have the NDA. We will not disclose any information. We will learn from the seller and its documentation. And now this is the legal stuff happening, legal due diligence or legal audit. As I said, it's very important because it helps the purchaser understand the conditions of the business or of the asset or rights attributed to the assets. So there is a bunch of document that needs to be uploaded to some virtual data room, and we lawyers love to read all of those, and we will request many of them in order to make sure that everything is as should be. So this is how the legal stuff happens here. Yeah, I have the note about the competition law, which I have already spoken about. So also it's important to realize in this phase, if this hasn't been dealt with earlier, if the transaction is supposed to be notified to the competition authorities. What do we search for, or what do we want to see in the due diligence process? We are here at Games Gathering. It's relevant. The IP might be relevant for us. So let me just briefly give you one example. An investor might be interested in a project. And it has some intellectual property in it, meaning some software, graphic features, some music, maybe some sounds, and all of this is put together within. I would call it a project, and I want to purchase this project. I want to buy this project, so I will do it, and I believe that I can push it forward and it will make profit. And once it begins to earn money, I want to make sure that no one will have the claim to chase the money from me. This is why all the copyrights to the respective elements of the purchased project needs to be purchased in the package. So that's why we lawyers love to see the track of documentation in the IP, meaning agreement on development of softwares, agreements with the authors, with the artist, on development of various graphic features or music sounds. So we need to see these in order to clarify that yes, there is a track of the copyright from the author, which needs to be natural person, up to the seller or eventually further to the purchaser. So this is why this is important. But besides these copyrights, we also want to see if there are any patents or trademarks or some rights to the website used or social media profiles. So this is the scope of, let's say, IP due diligence. And further, I happen to be a tax advisor in my career as well for a certain time. So I learned that how important financial documents are. And I would like to stress this because there are some cases where taxis are the one that decides to pursue the transaction or not. And also I happen to be at one that that was cancelled due to the fact that the seller would be taxed by 50%. So he decided not to pursue the transaction. So my advice is also for the tax consultants, but I understand their role and it's very important in the transactions. Yeah. Besides that, we have the commercial contracts that we review. In principle, we focus on those that are important, like material contracts, major suppliers, major customers, or if the loan agreement doesn't have any change of control clauses, which would mature, or which would mean that the loan would be matured and needed to be repaid upon transfer of ownership. So once the owner will be different, the bank will come and say, "Hey, give me my money." So this is something that you want to avoid. Besides this, I will mention maybe a corporate part of the due diligence. It's important to understand that even though we don't need to, well, even though we are buying asset or we are buying a share, there might be something that will be required, and it is approval of the general meeting of the seller and also maybe of the purchaser. But at this, let's say, seller, and as such, we need to review the constitutional documents of the company to understand if such approval is or isn't in place. And if it is, then it's very important for the efficiency of the transaction to achieve and to get this approval. Okay, so is due diligence or legal audit, if you will, necessary or it's not necessary? From my point of view, legal due diligence is so important because it answers the question if I what I think I am buying. And as regards the IP, it answers if there is a continuity of the transfer chain of the copyrights from the author, which is natural person, up to the seller and further to the purchaser. As I mentioned, also tax and financial DD are very important because you need to know what you are buying. And also if there are any fraudulent reports as regards to business, you don't want that. You don't need it. So how can I save money for due diligence? Because if it's necessary and all this stuff we need to review, I guess that the advisor might be costly. Can I hire a cheap consultant? How can I save the money? I would suggest that if the consultant is too cheap compared to the market, he might not have enough experience, and there is a risk that he will not address all the issue that need to be addressed. Therefore, my suggestion is to effectively use the resources and focus on things that are important. So tailor the scope of the due diligence. I will give an example. Maybe there is a standard version of the agreement with artists, with the developers, that is used with all of the developers. I don't need to review all of them. I will be happy with the review. So this is something that I can think about when tailoring the scope of the due diligence. So we ended up the due diligence. We requested the documents, we reviewed the documents, and found out some findings, some risks, and also we discussed them with the seller, and somehow we managed to agree on the price, agree on terms of the transaction. So we are now signing or preparing the SPA, sale and purchase agreement. We cover what are we going to buy, what is the price for that, which obligations still are to be performed by the seller before the signing. For example, obtaining already mentioned consents of the general meeting, then the signing of the SPA, which is very fancy event in a legal environment. Yeah, everyone is very happy, but the lawyers have endless nights in order to prepare the documentation. But still, it's very, very big event, and we are happy about that. But afterwards, it has not been finished yet. Some conditions precedent need to be fulfilled, such as maybe some termination or a settlement with employees, or some settlement of the disputes that have been discovered, or obtainment of a clearance of the competition authorities or something like that. So these are the conditions that that need to be fulfilled in order the transaction to be effective. Very important part of the SPA is representation and warranties part or chapter, covering the conditions of the business. And this is very important as it reflects the findings and flags that were identified during the due diligence, the legal audit. And also, this is the part when the seller specifically and in a binding manner states that the company is in this kind of conditions. All the documents that were uploaded to the data room and reviewed by your lawyers have been truthful and in their entirety, and so on. So it's very important part because this is something that binds the seller. Okay. As I mentioned, this is maybe what I have already covered, but in fancy slide. But there is another question. How can I secure the transaction? How can I secure that the money I'm willing to pay to the other party will be transferred there, and I will not get what I wanted, or the seller might not be willing to transfer the assets until it receives the money. So many times the notary or bank escrow is opened, and it's like in between the parties. This is the position in between the parties. The seller or the purchaser will transfer the money to the bank or to the notary, which notary certifies that it has obtained the money. Meanwhile, and the seller is happy that yes, the purchaser has already paid, and if I meet the specified condition, I will get those money. And at the same time, the purchaser is happy about that because yeah, I sent the money, but the seller has not received them yet, and he will receive them only once all the conditions that we agreed upon in the share purchase agreement have been fulfilled. Another option might be retention amount. As I mentioned, representations and warranties are, let's say, specification of conditions of the business. And if they happen to be false, and the purchaser will learn that after the transaction, it might bother him. But moreover, he would have claim towards the seller. But what is the easiest way to enforce such a claim? It's to retain or to not to pay a portion of the price and to keep it for a while longer, maybe for a year, 2, 3, whatever the agreement would be, just in order to make sure that I will have a portion of money that I will easily can set off with my claims towards the seller. Okay, so this is like the retention amount. Let's maybe mention also the contractual penalty for maybe breach of obligation of some warranties or representations. Okay, so this was the first part, in which we briefly ran through the transaction from the commercial or transaction legal side. And now I would like to focus on some pitfalls or risks that are usually present, and especially in the IP or focusing on IP in the transaction. Well, so what are the common IP flags? As I said, as lawyers, we need to track the copyright. We need to track the ownership of rights from author up to the seller and then further to the purchaser, and conditions of the transfers, continuity of this right. If we don't see the documents supporting this, it is a flag. It is a risk, and it needs to be addressed. It might be addressed as obligation of the seller to furnish this documentation, or maybe obligation to indemnify, but it's very risky if it's important part of intellectual property. Okay, so missing documents are very, very, very common, and not only for the IP, but also for other streams of the legal audit. And yeah, the second is incomplete chain of copyrights. I happen to perform intellectual property due diligence for an it was a, let's say, startup who was seeking for an investor from US, and they wanted to make sure that their copyrights were correctly attributed to their limited liability company. But unfortunately, it happened that in some at a certain stage of their startup, they needed to switch the vehicles, and it happened that they dissolved one limited liability company without transferring those copyrights to the further company, and therefore it came back to the original author, natural person, which wouldn't be that bad, but actually the shareholders of the new limited liability company weren't anymore that friendly as they used to be, and the former artist was not willing to cooperate and come and agree on some kind of settlement. So it was not very happy. But yeah, this is kind of stuff that might happen, and I'm just this out in order to for you to think about this. Further, I might mention open sources, open source softwares. These are many times they are part of the commercial softwares, but it's important to see or to observe if the license, open source license, enables commercial use. Many times, this kind of licenses prohibits commercial use and requires that the derived works would have to be published under the same license or maybe more copyleft license, so more free license. There are still some licenses that open source software licenses that can be commercial used, but it's important to think about this because from what I see, many times developers just reach out to the available software, put it together, and don't think about this legal stuff behind. But even though it's free, it's not free to use in any manner, and even not following the open source license is infringement of the intellectual property rights. And there are some cases when Free Software Foundation was very successful against the major players, and they closed with settlements. And at the end of the day, the commercial software needed to follow the open source license, and also some compensation settlement amount needed to be happy for the business. Yeah, maybe the other flag is inability to provide list of used open source software or list of softwares at all. So this is, for us lawyers, it's important to have the evidence and to be able to verify the track record. What is worth mentioning is if purchasing a product or business in one jurisdiction and want to use it in my jurisdiction or vice versa, I need to take care about licenses, if they are territorially limited or time limited, and if I will be allowed to use these licenses in my jurisdiction, or I should extend it. Further, I can mention maybe expired trademarks, and it just good to know. It might not be the biggest issue, but still, it's important to be able to see what you have as regards the trademarks. Okay, and disputes regarding the use of trademarks and other IP rights. It's very important. If there are any disputes concerning this, if you are purchasing something that the IP is very substantial part of, then you want to make sure that you understand the litigation behind, and want to make sure that in the event the litigation will not turn out well, that the seller will compensate you. Okay, these were like main IP flags, I would say. I would like to mention maybe some corporate flags. It might not be that interesting for these on the audience, but still it's very important, and I would like to stress just 3 of them. And first one is if you happen to be in business with someone and you agree that, okay, if you bring me new customers or you open new opportunities or whatever, you will receive some share, some equity share, and you are glad about that. And yes, that's awesome. Let's do this. it's fine for you to understand and have this kind of business agreement, but once once you reach the point you want to enforce this, it is much better if you have it written on a paper, or at least specifically defined and exchanged via email or something like that. And the best place to put it is the shareholders agreement, which is also the second flag I wanted to point out. If the shareholders agreement isn't there, is missing. Yeah, so I can mention those, and maybe I will add third one. We review also the management contract, and maybe good to know. I think that is good to be known is if the management can be replaced and under which conditions, and if they have any golden parachutes or some amount or big amount that would need to be paid to the management. Okay, these are just further flags or problems. Missing documentation, change of control, I've already covered that. Pending litigations. Okay, so this is like the stuff that we wanted to cover. I maybe just add one more thing. As I'm from Slovakia, there are some opportunities in Slovakia. I'm here like a pioneer, but Slovakia is very good located in terms of Europe. It might serve as a gateway to the single market, and also Slovakia is in Eurozone, which might be beneficial for the businesses. Also, Slovakia is good for proximity of various international airports or even the arbitration tribunals. So if you're thinking about going to European market, Slovakia might be worth considering. Okay, so this brings me to the end of my presentation, and I'm happy if there are any questions. I'll be glad to answer them.
Okay, thank you, Batista, Stefan, for your presentation. Very informal, very interesting. So we're waiting for some questions. Meantime, I can ask you maybe what is the most important part of the transaction?
Okay. So for me, well, in principle, most important part of the transaction is documentation, because it is the vehicle or the method how you will reach the desired outcome. But I would mention also due diligence, because it is something that makes sure that makes you aware of the conditions of the company. So maybe this might be a frank answer.
Okay, so maybe you mentioned that this transaction limited in time. So why is it so important?
Well, if you don't have enough time, then yeah. Actually, my first reaction would be to try to expand the time, because the transaction might require some time. All those steps and all those processes. But still, if there is no time and you really want to pursue, I would focus on representations and warranties, and also maybe cover or include sanctions that would guarantee your position. So this might be interesting to think about.
Okay, so we have one more question from Pine Platform. Is there a text or book on these topics made for a layman?
Uh, yeah, actually, there are multiple books covering the M&A. So in principle, it's covered well, and I would suggest, if someone would be interested, to search for either international concept of the M&A, or locally well reputable authors, but it may differ from jurisdiction to jurisdiction.
Okay, thanks for your answer. And maybe one last, why spending money for lawyers is not maybe so bad idea of using your resources.
Okay. As I mentioned, if you don't uh, consider various questions at the beginning, there might become problems at the later stage. Therefore, it's worth just, hey, stop, relax, think about that. And this is the part where a lawyer can be very helpful, because also from my experience, um, there was a problem that, yeah, there was an informal agreement about some new shares to be distributed, and it was commonly agreed, but it was not written down. The mechanism was not there, and when we came uh, to the enforcement of this promise, or enforcement of this situation, this was quite problematic. So if they stopped by earlier and thought about this in the initial stage, where willingness of both parties was to reach agreement and to express their will towards the cooperation, they would not end up with not pleasant situation at the end.
Okay, very interesting. Thank you. Uh, One, you have mentioned one statement that ability to prove the ownership of IP is crucial for successful transactions, email transactions. So the question is how it is possible, maybe some easy or hard way to prove your ownership of some IP.
Mhm. In principle, you need to track record the well. Okay, first of all, it's good to know that only natural person, such as artists, can have originally the works.
Mhm.
Uh, there are some exceptions where some of the copyrights, such as the right to transfer or right to sell, vests towards your employer. So we would see the contractual relationship between the employer and the employee, or between the software developer and the one requesting the software to be developed. So we would review those contracts, and if there is
Mhm.
evidently regime that the copyright vests at the level of the employer on the party purchasing or ordering the development, then this is proven, and afterwards, yeah, we can say that this company is allowed to transfer it to the further companies.
Okay, thank you for your answers. As I can see, it's pretty old questions. So thank you, Stefan, again for your visiting, for your presentation. Very interesting theme. Hope we'll see you later with something.
Yeah.